everyone. Welcome to the next episode of the Schmoozin with Forouzan podcast. As usual, very happy to have our guest here today, Sam Sani. Sam is a plaintiff's employment attorney. He was previously a defense attorney, and I've not only been his friend for a while, but I've had the privilege of working with him over the years. And I'm incredibly impressed by his work product. I think when you have someone on the podcast who has experience from multiple perspectives, here we have a guy who's done both defense and plaintiff's work. I think it's so useful. It's so great to be able to ask people with these multitude of perspectives questions. And today we're just going to hop, I guess, pretty deep into civil litigation, in particular employment litigation. Mr. Sani,
Yeah.
how are you?
Hey, Dan, thanks very much. Let me start off by saying thanks for having me on this podcast and congrats on the success and the West Side Bar Association, everything you do outside of what I know is a very successful practice that you have. So excited to be here. Thanks for having me. I'm doing well. We're recording on a Friday, so I can't complain.
Yeah, there's a reason I do all my podcasts on a Friday. Everyone's happy.
That's
Everyone's
right.
happier that way. Okay, so look, I actually, for the first time ever, have not produced any outline for my podcast. We're doing this ad hoc. That's partially because I'm friends with Sam and I think it just makes sense. It's also partially because I know exactly what I want to ask the gentleman here today. But before we do, let's get just a little bit of background. I don't like to go too deep into where were you born and what school and GPA, just general broad strokes. Can you give us your background as a lawyer, how you got started and how you ended up where you are today?
Yeah. So when I came out, I actually kind of knew I wanted to be in the employment area during law school, oddly enough. And so when I came out, I was looking at a pretty bleak market
Mm.
and limited choices in terms of employment. But thankfully and luckily, I know some folks out there have their opinions, but I was very grateful for the opportunity to work at Littler Mendelsohn when I came out of law school. And let me preface that by saying when I was in law school, I was, taking all like I didn't enjoy law school very much, but I was trying to do as much of the practical clinical courses so that when I would
Mhm.
come out, I can kind of, hit the floor running. That's what, the '08 crash when you're in law school does to people.
Yeah.
Forces you to try to be as productive when you come out. So anyways, I came out and I joined Littler here in Los Angeles, and I was, very pleasantly surprised because even when I was in law school, I did a summer with them, and shockingly, I think even to this day, most people, if you ask them there, would say it's probably rare. But I got very lucky that I got thrown on a trial team during a summer program, and I was just able to sit in on a trial, and I was able to do some very minor projects for the trial. But it, at the very least, let me see what an employment litigation, what an employment law kind of trial in a courtroom looks like. And that can say most of my colleagues to this day may not even seen that,
Mm.
right? And so I knew I was kind of hooked that that's what I want to do. And coming out, I spent about 5 years at Littler doing the defense side work. um, it's a big law firm, so there's kind of steps to this. And the first few years, the work was very different. In the second, third, fourth year, so there was nice progress. But somewhere around the fourth or fifth year, I kind of started hitting some walls, not just in the practice, but also just like career goals and where I wanted to be, and also personal life goals and where I wanted to be. And I just didn't see them maybe running parallel as I wanted. After all, like most firms, large firms, it takes time to make partner. And even if when you do, the skills and responsibilities and autonomy really that you have over your day-to-day life, your practice, the types of cases you want to practice, there's nothing like being your own firm or having a partnership of yourself. So somewhere around, I'd say the fourth year or so, I started having that little tickle and thinking, you know what, I don't know if I'm cut out for it. The lifestyle, really more than the practice of being like a big law partner. And I was always already married and settled down. So, I kind of took the leap, and I figured, let me try this out for a few years and try to build something of my own. And if it wasn't going to work, what's the worst that could happen? You can always come back and go in house, whatever. There's tons of different choices. But I was very lucky, Dan, because I knew I wanted to do employment law. I wasn't like searching for any other area of law, and you know, and I was happy doing it. So that's very much a privilege of the work that I do is I actually enjoy the work. So once I came on the plaintiff side, I kind of like fit like a glove
Mm,
because so many of the different types of some of the things that were missing from my like lifestyle and practice at the big firm, I was just able to walk right into everything from being able to say no to cases that I just didn't think were viable cases, but also just would not be a fun time litigating that I would
right.
have to say yes to if I was on the defense side, working at a firm because that's billable work and the client is a client, to just being able to craft my own path in how big of a firm, how much I want to work, when I want to work, those sorts of things. So for now, this is going into my eighth year. Geez, yeah. So somewhere around my eighth year now, since I left Littler. It's yeah, 2015. So it's been a roller coaster. I mean, I won't lie. The first year or two was pretty rough. COVID was tough for everyone, but I wouldn't go back. And so now I'm full time plaintiff side. We do a mix of class action, wage and hour, and single plaintiff cases. Everything from wrongful term, retaliation, and we've done a couple of cases together.
Mm.
So it's fun times. It's a lot of fun.
That's wonderful. I mean, I know the feeling. I went on my own, and like you said, I've worked with you, and it's such a different experience. When the case is your own, it's your baby. So, last night I was here till 9:15, 9:30. I didn't mind because the case was my own. I'm sure you've
Yeah.
experienced that as well. So let's hop into this because you are a gold mine of information. You have worked on the dark side, and therefore you have information that a lot of plaintiff attorneys might not be privy to. And I'm gonna preface this with saying I have personally had a lot of insurance defense training. The first work that I did was corporate litigation. I then had very, very intimate defense side training from a mentor of mine. Obviously, I reach out to people like you to work with you. I love getting perspective from the other side of the aisle. I think it's invaluable, and I'm surprised more lawyers don't do that. So I think that's probably what we'll focus on here today.
Yeah.
When you were at Littler, what was it that you noticed in terms of these were the hot button issues? These are the causes of action that raise the temperature. These are the things that push cases forward. Or similarly, the flip side, what kind of things do plaintiff attorneys do that people on the defense side are kind of chuckling at?
Yeah, well, I think that on the from the defense, I mean, it's been a while. I'll say that, but when I was on the defense bar, for for a successful plaintiff's attorney, an effective plaintiff's attorney, really, the term being aggressive is used all the time, but it's being efficient and effective more than anything else. And every employment case, if you're going to litigate it, it's won or lost well before trial. It's discovery, right? It's the discovery battles, it's the depositions, it's not being scared to spend money to go after the depositions that you need to take, and it's not being scared to if you have to dismiss some claims because they don't pan out, that's fine, but you're still going to turn the rock and see if there's anything there, right? So I found like in the defense bar when I was at Littler, there were those attorneys who would file a case and would come in, and you knew that, yeah, there would be a depot, there would be some discovery, but you didn't need to necessarily respond as and be worried about a motion to compel in every single instance if you didn't respond thoroughly.
Mm,
If you didn't. Obviously you're going to hand over all the documents, but if the descriptions were vague and you deliberately kept them vague or something
yeah.
like that, in some of your responses, you weren't going to worry about it as much because you knew X or Y firms, they're what we would consider like a mill firm or a larger firm, and they're not as aggressive. They have to file their cases and get them settled. Vice versa, you had your firms that you knew they were trial firms or they're heavy litigation firms. They were going to cost your client a lot of money to fight. Forget about winning. And so I think that's pretty well known, but how that actually pans out in practice, case by case, and building a reputation as a firm on the plaintiff side, more than anything else, and being willing to take a case to trial. more than anything else, spoke volumes on, when a case came in by and you're defending it on the defense side, and those initial conversations with the client, you know what I mean? Because the client's always going to tell you on the defense side, this is BS. This more times than not, this is BS. It's false. There's nothing to this. This is why we shouldn't pay anything. I can't believe this happened. But at the same time, your job is to try to advise the client on what the risks are, and if that conversation includes, by the way, I know the attorneys, or I know this firm, and this is not a firm that's just going to go away with a few calls and a discussion about mediation to see if they'll settle for cheap, or settle at a discount because we're coming to the table early. That's not what's going to happen here. So I think really developing that relationship and reputation on the plaintiff side is key, and that also requires, it requires being measured. I know plaintiffs' attorneys, I'm sure you do too in your area as well, where every case is like, some attorneys, it's like a bulldog fight from beginning to end, and that's how they operate. Their personality is that way, and that's just, they don't know any other way, it seems like. And power to them, that's for them. But I would posit that that's not really the most effective way to be a plaintiff's attorney, because you're ending up spending a whole lot of resources on cases that may not need it. And on the same token, the defense bar is not going to necessarily respect you as an effective attorney who knows how to push the buttons. The other thing I would say is, also going back to my earlier point about discovery, is depos. Knowing how to take a good deposition and defending a good deposition, and not being afraid to cut questions off when they're inappropriate, or not being thrown off by BS objections, and just staying calm and knowing what you need in a depo and getting it. And if they're not giving it to you, saying, that's fine, we'll go to the judge, and going to the judge when you need to, and knowing when to pull that trigger. Those depositions, and knowing how to take an effective deposition, not just, by doing it a few times, but really knowing the different tactics in a depo and the defense bar's tactics in the depo. Very, very helpful. And that's, I thought, very telling stage of the case from the defense side, seeing how a plaintiff counsel shows up and how prepared they are. And frankly, when we're taking their depo, when I was on the defense side, how prepared is the plaintiff's, when he or she show up at the deposition. You can tell when they've been prepared or they have not been prepared. And it makes a difference. It also leaves an impression as to how that case is going to proceed with the plaintiff's attorney. Is this really a case where the attorney is looking to take this to trial? Not after a plaintiff shows up and just, is clearly not prepared, and just saying, I can't recall to every answer, to every question, except a few questions that, they were told to say X, Y, or Z. Well, okay. It's clearly this guy's or woman's credibility is going to be kind of shot through. But so, those are a couple of points that I think really stood out when I was in a defense bar. Obviously, trial practice and arbitration hearing practice is a whole separate beast, and there's a lot more tactics that go into that from the plaintiffs and defense side perspectives. But really, in the kind of litigation process, the nitty gritty of it, those discovery battles, and knowing how to effectively go after the other side, but efficiently, professionally, I think it goes a long way.
Interesting. Let me ask this. I have 1,000 things I want to follow up with. The first thing I want to do is, it sounds like the plaintiff attorney's reputation matters.
Yeah.
I think, generally speaking, any profession, whatever it is, reputation matters, obviously. However, I go to certain seminars and this and that, and you do hear lawyers say things like, oh, the defense side, they're keeping tabs on you, or they're reporting to their client about you, yada, yada, yada. My question, but then I speak to defense attorneys, and it's more wishy-washy. It's not like there's a system necessarily, but I'll turn the question to you. Is it that you literally have a matrix of all the plaintiff attorneys, or is it just water cooler talk, associates and partners talking about their impressions of various firms?
No, I think it's not very dissimilar from what the plaintiff side does. If you are a member of some of these listservs on the plaintiff side, or any bar association, you'll even see it on some, non one-sided association email servers. Well, they'll say, does anyone have any information about this firm, right? That's a version of that question gets asked, whether you're on the defense side or you're on the plaintiff side. and how broad of a question it is. I mean, when I was on the defense side, and some of my colleagues before me got up and left, and they joined the plaintiff's bar, they would file a lawsuit. I defend the case, and folks would ask, what do we know about this former Littler attorney? And the responses would just come through. He's very effective at this, or he knows how to do that, and he tends to have this kind of propensity. So those responses would leave an impression on the attorney who's handling that case. Similarly, on the plaintiff side, we do our diligence on the defense attorneys, we do our diligence on the insurance companies, we do our diligence on the defendant sometimes, who the client is on the defense side, to see how they've handled other cases. So it's a similar kind of diligence. It's not, I didn't keep track in terms of a matrix or an Excel spreadsheet. Maybe some do. But suffice to say, if you are, a litigator and you've been doing it for enough years on either side, you're going to have a track record, and people are going to, ask about you, and there'll be a response within a firm, particularly in an area like employment law, where you have a sufficient number on the defense side. You have a sufficient number of big firms where they get a lot of cases. You have your Jacksons, Lewises, and Morgan Lewises, and so on and so forth. And those guys, if you've done litigation for enough years on the plaintiff side, you're going to sue their clients at some point or another, more than once, right? And it takes, it takes a few cases, and you leave an impression, good or bad, right? And that doesn't necessarily mark you forever, but that's where you grow from. And I frankly see those as opportunities, because when I get a big firm on the other side, Littler or not, I see it as an opportunity to leave an impression, professional but aggressive, so that the next time and the next time and the next time they know what's coming. And similarly, when I was on the defense side and a client would get sued, the reputation of the firm kind of spoke for itself. But within a big firm, it was kind of different, because each attorney and each partner has their own reputation a little bit more. Whereas, on the plaintiff side, you don't have as many big firms like that.
Interesting. Okay, so it sounds like I'm hearing arbitration and trial were differentiated. We were focusing, it sounds like, on litigation. And to be honest, some of the things you said were music to my ears. I agree that discovery is incredibly important. And I do find it's funny, once my insurance defense side mentor began pointing out to me how, especially in the personal injury practice, the defendants withhold information, whether it's vague answers to discovery, which are evasive or non-responsive, or whether it's, objecting in a certain way that allows them to withhold certain things, or frankly, if the plaintiff attorney asks bad questions,
right?
Yeah, it was, especially in written discovery, that are easily objectionable.
Right.
Or the questions lack specificity, or they're not delineated, and various other things. Once I began speaking to an insurance defense attorney and she began mentoring me, I became much more aggressive, mostly because I didn't want anyone getting one up on me.
Yeah.
I saw the defense has an interesting way of doing things that's different from the plaintiff, where at least in PI, the plaintiff's attorneys, they get a win, they announce it, it's a big deal. The defense, they get a win, you might not even know it was a win. You might think the defense lost, when in reality they're high-fiving themselves behind closed doors. And that's an interesting thing to me, because it does put the onus on discovery. Let's talk about depositions. You mentioned that, does the plaintiff attorney know what they're doing in their deposition? Okay, when you were on the defense side, what did you notice plaintiff attorneys do in depositions that you thought was effective?
What did I notice plaintiff attorneys do that I thought was effective?
Absolutely nothing, Daniel. They all sucked.
Well, no, it's not. Well, no, it's not that. It's that, I didn't see it so much during a deposition by way of the plaintiff's attorney. I saw it by the performance of their client. It was abundantly clear to me which client had sat down for enough time. Let's leave it at that, because I've come to understand that different attorneys spend different amounts of time with their clients for prep. But to sit down with them and really walk them through what that day is going to look like. And then the attorney that's met with them an hour or two before the deposition said, here's what the basics, essentially. So there was that. Okay. So there was obviously the performance of the client themselves. I will also say, like, certainly not in my beginning of my practice, but eventually, as the years went on, you get to understand what the key quickly understand what the key issues and what you need out of a deposition. And from a defense side, um, you know, not all defense attorneys will tell you this, but the truth is, if you walk out of a defense plaintiff deposition and you get one or two admissions, just a few good admissions that can allow you to bring an MSJ or an MSA, it's a good day. It's a good day because it is not hard for a plaintiff to defeat MSJ, MSA if they are properly prepared and to say the truth and to say it effectively and to not be, mismanaged or thrown off by the way the questions are asked. If they're prepared properly, it's very easy. I would suggest in good cases, okay, how about that? To answer properly, make sure you defeat MSJ or MSA that may be forthcoming. But I'll say, even when I had a client that was insisting on bringing MSJ, and I knew, so going in, the pressure is on because we need to bring an MSA in this case or an MSJ. That's what the insurance company or the client wants on the defense side. And I'm taking this depo, and I can tell that, this plaintiff is well prepared. My goal wasn't to win the case that day. My goal was to get just a few enough admissions, okay? And even in those instances, I'll tell you how effective the attorney is during that day, because sometimes you ask questions in deposition that maybe are worded differently or they're too broad and they could include other things that the witness is not thinking about, or the different strategies. It takes one moment for that plaintiff's attorney or the defense attorney, when they're defending, to be on a phone or answering an email or doing something else, their attention is not there, and you get a question by. So that's why I actually always say defending a deposition is much, much harder than taking one. I hate defending depositions. I do it all day, but it's not my favorite thing to do because you kind of basically have to be on and not have a moment of a break until you're off the record. And not even a cerebral, let me see what the next question could be. You have a moment to think about that question and object or not object. And you don't want to be on the record objecting every single question, because then, you're going to look terrible in front of the judge one day, perhaps. But I think also taking a step back for a moment, like a bigger question is one thing coming from the plaintiff side, coming to the plaintiff side from the defense side. I think what plaintiff's attorneys don't understand, or a lot of them don't, if they've never worked on a defense side, is understanding understanding what is driving the defendant in a case.
Yeah.
Right. And there's a lot of variables to that. But I think, and we can talk about them, but I think that if you can, as a plaintiff's counsel, understand what is driving that particular client on the other side, is it the attorney? Is it insurance? Is it emotional? Is it a business decision? If you can find that out a little bit, it can go a long way in determining and kind of really honing in as a plaintiff's attorney with your strategy is how to litigate this case. What are the pressure points? Does it make sense to let this case sit for a little bit and then pick it up? Does it make sense to go uber aggressive from the very beginning? Does it make sense to have a phone call at the early stage of the case with the defense counsel? So I think a lot of times we wish, and for better or for worse, a lot of plaintiffs' counsel will try to make employment practice a cookie cutter practice, but it's impossible. It's very difficult if you want to squeeze out as much as you can from each case and make sure you're getting the best you can for your client, because each case is different, and most defendants are one from another have very, very different motivations in each case.
How do you go about, especially having your perspective from behind the curtain, how would you say it's best to go about determining that? I mean, obviously, if they have insurance versus if they don't have insurance, it's two different things. If you're dealing with a large corporation, they have exposure to the media and things like that. Obviously, that's a thing as well. But what, aside from the obvious, how do you go about making this determination?
Yeah, I mean, so different. There are many different stages to that. It's not always something you can find out at the very beginning, but at the beginning of the case, for example, you will want to figure out, obviously, if it's a Walmart or a big company, that's one thing. But if you're suing a company that you haven't heard of, or you've only heard of it tangentially, you want to do your diligence. Have they been sued for this type of a case? Have they been sued before at all? Do they have experience being sued? You ask your client, you do your diligence online. So whether they've been sued and how sophisticated they are is one thing. Also, at the initial part of the case, most cases, I'll get a call, from either an in-house or an outside counsel. They want to introduce themselves. Nowadays, They all want to talk about some sort of a settlement, which is something that's changed post-COVID. But, and I think that a lot of plaintiffs' attorneys take that first call. It is a very guarded call. Like they're trying to find out more about my case out of discovery, or they're, do I find out if they're trying to settle this for cheap, or why are they proposing mediation? And there's all these strategies. For me, I see it as an opportunity. I want to get to know the defense. I want to get to know, how did they get this case? You know what I mean? How many years have you been? I mean, these are questions I'll ask defense counsel, especially if I have a relationship. How many years have you been practicing with this client? You know what I mean? I want to know, even if I have to ask it like in an informal way, what is the relationship between this attorney, this firm, and or that attorney, and this client? Is there a relationship there? Because that'll give me a signal of how much pull this attorney may have over this client. Sometimes I'll ask that of the associate even, right? Because the associates will be less guarded about that sometimes, that information. That's very important. I can't tell you how many mediations or just cases where I'm like scratching my head, not understanding until I realize why the attorney is not able to get through to their client, or the client is not listening to their attorney. And so I think understanding the relationship between the attorney and their client, and is it a new relationship, an ongoing relationship, what type of client it is. I'll have defense counsel sometimes tell me straight up, this is a very aggressive client. They won't listen to me all the time. I will, they'll make that admission. Sometimes it's puffery, right? And you can test that very quickly by seeing how aggressive they are in litigation. But sometimes it's not, right? And so I think figuring out some of those things, figuring out, what type of client it is in terms of, is it an emotional client on the defense side, or is it a business decision type client on the defense side? Usually, if there's insurance involved, it's the latter. And then, from like a PI perspective or some other practice areas, that's usually a good thing, right? That there's insurance involved. And generally, big picture, yeah, it is. You prefer to have insurance, obviously. But with insurance also comes certain opportunities and setbacks. By that, I mean, there are insurance companies and then there are insurance companies. Some insurance companies don't care how bad a case is. They want to litigate a case up to a certain juncture, right? And from a plaintiff side perspective, they will not pay unless and until you punch them enough times or get past MSJ, metaphorically, folks. You get past MSJ, and you show that you're not afraid to take the case where it needs to go. They won't take you seriously. And that goes back to, your reputation and so forth as a firm and as a practitioner. Vice versa, there are other, insurance companies that they're not in the business of paying their attorneys too much. If they can settle something, maybe more than they want to, but certainly less than how much they would spend to get through MSJ, yeah, they'll settle it early. And so over time, you'll learn. Obviously, I'm sure Dan, in PI, you have different insurance companies have different reputations, and you get to understand those reputations a little bit, and that can inform how you litigate the case and how you push the case along, and when you maybe have some conversations with opposing counsel about resolution. So those are the kinds of things I think most plaintiffs' attorneys learn over time. But coming out from the defense side, I can't emphasize that enough, because I don't think the plaintiffs' attorneys value that as much. And it goes I would say the other way as well. Sometimes maybe you've called me or some other folks have called me and they're like, I don't know why these guys are litigating this as hard. Like, I have these facts, I have this evidence, I've turned it over. Like, they're still making these BS arguments that are just facially, they'll bring a motion that they're going to lose. There's no way a judge is going to grant this motion. And they're right. The judge eventually doesn't grant it. And I got to tell them, like, listen, this is not about whether they're right or wrong on the law sometimes. They're just doing their job on the defense sidebar, right? They have an attorney, usually an in-house counsel, that's telling them, this is how we want to do it. This is how we want to proceed. And they have to follow orders. And frankly, sometimes they may be selling their client to be aggressive because, the billables and so forth. And hey, why not? It's a shot in the dark. We have the budget until MSJ. Let's give it a try. And if we can't win it on MSJ or get some of these things kicked out, then all right, well, we can discuss mediation. So because it's a business decision, I almost kind of cut to the chase sometimes when I find out there's insurance, and I'll tell defense counsel, I'm like, listen, your insurance is this, the retention is this. You've gone through about that much. I may be off by some, but at the end of the day, you're not going to MSJ this, and every case is a market value. So you should go have a conversation with your carrier and your client, and I can put it in writing if you like, but the market value of this case at this stage is going to be very different than in 6 months when this is all going to have happened. And it'll be very different in 9 and 12 months, right? I will have that business side conversation without any qualms that this is not a business transaction, but because there are those kind of decision makers who are thinking like that on the other side. My client doesn't think like that. For my client, this is their life, right?
Yeah.
And so it's, in that regard, it's sometimes you on a plaintiff side, it's fruitful. Sometimes it's not, but sometimes it's fruitful because it also signifies to the defense counsel, you understand the position that they're in. You understand that they're doing their job, but where this case is headed, unless you get it resolved here or there, at this juncture or that juncture, it's a business decision. And I can't tell you, Dan, I've had one case that comes to mind now that I think about it. Man, it was my first trial when I was on the defense side, and we had litigated this case pretty aggressively. I was at Littler, and we showed up to mediation. I want to say it's like 3 months before trial. It was right before expert designations, right? So for folks who are not attorneys who are listening, basically this is the place where you're going to have pretty serious conversations about settlement. Outside of settling it on the steps of trial where the jury's being impaneled, unless it's happening then, this is where it's going to happen. With a mediation close to trial, you're past all your motion to dismiss deadlines, and you have a professional mediator. Mind you, that each side, I think at that time, almost a decade ago now, we had paid them $8,000 each side. It was very, very expensive mediator. We show up to mediation, and it was a misclassification case. Wage an hour. It was never going to be dismissed. And there was exposure. Not large, but there was some exposure. There's risk. And we show up and our client comes in and says, $15,000. That's all you have. And it was a very wealthy client, family-owned business, but that's all they were going to pay. And they said that includes the mediator's fees. And so we were sitting there within 2 or 3 hours. And by the way, those first 2 or 3 hours, we weren't even negotiating. It was just the mediator trying to knock some sense into our client on the defense side about what are you talking about? This will never settle, not today, not ever, in that range. So why are we here, right? So sometimes, and in that situation, I'll tell you, me and the partner, we were not happy because we had no signal that that's where it was going to be, right? There was no insurance, but it was you would know the name of the company. I'm not going to name it, but it was a very well-known company, privately owned. Tons of money. They had enough money to settle that case for sure. They had enough money to pay the judgment that the plaintiffs eventually won for $75,000 or $80,000 at trial. It wasn't a huge sum, but it was still a victory because their fees were going to come after that.
Yeah.
But we were blindsided as much as the plaintiffs' counsel. At some point, we went into the room. We're like, I don't know what to tell you. We were telling the plaintiff's attorney and the mediator, I don't know what to tell you. Our client didn't tell us this. We agree it's not fruitful to be here. Let's call it a day. And we left. And now that I think about it, if I was on the plaintiff's side in that room, I don't know if I would trust that the defense counsel didn't really know. But there are instances where it's just so client driven, right? And the defense counsel only has so much control, right? When there's insurance involved, that variable changes a little bit, that equation changes a little bit. But so that those kinds of instances come up as well. And plaintiff's counsel should be aware that it's not always, we tend to have the emotional clients, but there are some emotional clients on the defense side too.
Yeah, there's emotional clients on the defense side, but what's an interesting thing that was brought to my attention. I was having a conversation with my friend who works on insurance defense about media and this and that, and he made a point. He said, "Look, I get it. The defendant themselves might not like the bad press, but my client, the insurance carrier, could care less. It has no impact." So it's an interesting thing when you have a uninsured defendant. I guess you get one picture, and when you have an insured defendant, you get a different picture. I agree with you. I would still prefer an insured defendant, but there are certain stubbornnesses that I guess you can argue come come with having an insurance, having insurance where everything is effectively a business decision. You had mentioned earlier, look, you were giving me an example where you were explaining to counsel, hey, this case is going to be worth something more in so many months. Were you saying that because it was a suggestion that evidence is going to get uncovered? Or were you saying that simply because your attorney fees were going to accumulate over time?
No, well, on that case, it was because evidence was going to be uncovered, and I had already shown some of it. But in other cases, I'm not going to disclose evidence until it's disclosed, but I would may make mention of it. But it will also sometimes will just be as simple as like what you're suggesting, which is, listen, I have, 7 causes of action. You may win a couple of these. Heck, I may dismiss a couple of these without prejudice. But you're not going to MSJ the harassment or this one or that one. So if you want to force me to litigate this for another year, get it through MSJ, MSA, survive, be my guest. I welcome it. This is how I feed my family. I love to litigate. Right? I was invited to take away from the defense bar or defense counsel this notion that my client is somehow going to be rushing to settle because it's going to take that long, or they may lose a couple of causes of action. Because I will say, like, on the defense side, and this is a wrong notion. If there are any defense bar people watching this is the wrong notion that you guys have, which is, and I would hear it a lot of times that would be, this is how they would explain to their clients, this case has 5 causes of action. And we all know this case is about only the first cause of action. All this other stuff is just junk and made up. And we think we have grounds to dismiss it. Okay. So you're going to spend, 6 figures in fees to litigate this case, and then get maybe 4 out of the 5, maybe dismissed as an MSA, summary adjudication. And then you're going to expect that the plaintiff's counsel and the plaintiff, after all that time work, surviving MSJ, is going to somehow come to mediation or some negotiation and say, you know what, because you beat us at 4 out of 5, we're going to discount our value of this case. That is the exact opposite of how this works. And so I got, when I first came out, I got that a couple of times told that by a mediator and by a defense counsel. And so now, very early on in cases, sometimes, this past year I haven't had this in a while, but I had a demur filed against me. I called the counsel up and I said, I want to thank you for filing this demur because I love demurs for 2 reasons. One, judges hate demurs. Yeah. So guess who's going to love me, right? Yeah. And number 2, when I beat your demur or you win and I have to amend and I have to spend more of my client's money, one day we'll be talking about how to resolve this case. And I want you to remember this moment when you chose, not me, your client chose to rack up fees, right? You could have litigated this case. You could have come to discuss settlement, but you didn't. And I'll tell you, I don't pull punches. I'll be very upfront about your client is the one who's racking up the fees. Because, there's this reputation. And I see articles. I saw an article last week about this PAGA case, this meal arrest break case where the value of the meal arrest break violations was like in the low 5 figures, but the attorneys are going to make 6 figures. What they don't tell you in that article is that there probably could have been a settlement if only the defendant had come to the table, or if only the defendant wasn't super aggressive in that case, right? They don't tell you that those fees a lot of times are because the defense bar is so aggressive in how they litigate. Yeah. And they're not handing over documents or they're not responding to discovery the way that we need to, And so they force our hand to litigate the case more aggressively than we maybe even intended to in the first case, right? I can't tell you, and I've seen it, I'm not trying to point fingers or make accusations here, but I have seen a pattern. I don't know if you have, post-COVID, where it's kind of gone to the extremes. Some cases now, I have opposing counsel who will call me early on that I would not have expected and try to have this conversation early on. And they do, some of them want to have a reasonable conversation. Some of them is the old traditional, can we settle for cheap, it turns out. But I'm having more of those conversations earlier in cases than I did pre-COVID. And then on the flip side, I'm also having cases where it seems pretty simple. There should be an avenue for how this should get litigated. So your client and my client have enough information to evaluate, and we should be able to discuss settlement. We don't have to agree at mediation, but at least have a discussion about settlement. Now, instead of that, I'm getting like 3 different sets of demurs. I'm getting like discovery and then motion practice on discovery that I would never have gotten because I'm all about handing over what I got and being forthcoming so I can avoid a judge looking at me and asking me what's going on.
Mm-hmm.
So it's almost like they need to bill, or they're looking to be more aggressive than usual to set some sort of a tone that I just, with the same firms, mind you, like I've litigated against these firms before, but something's changed. And, in my now 7 years or so on the plaintiff side, I've never had a counterclaim filed against my clients until this year. Right. And I know that talking to some other plaintiff's attorneys, that's been happening more and more as a defense tactic. If there are any defense attorneys watching this is a bad strategy. It only makes us more aggressive, and it only racks up more fees. It just doesn't work. I mean, you can have faith in your claims against my client, but I will tell you, it's only going to make resolution of the case at any point much more difficult, and the cost of litigating the case much more. Why not instead discuss resolution and bring up those claims and show us your evidence, instead of going through the rigmarole of making a whole other set of litigation that it's only going to make it more difficult to resolve the case. And frankly, from my perspective, are meritless claims against my client to put fear in my case, in her.
The attorney fees under FEHA, they apply to, do they apply to defending against a counterclaim as well?
No. So the counterclaims are usually non-FEHA based claims. An employer brings a counterclaim. It's usually for not related. It's not a FEHA based statute claim. It's usually for maybe some misappropriation, allegedly, of trade secrets.
Exactly.
Interference with business relations, fraud, deceit. I mean, the one I have now is ambitious. Let's just leave it at
that. I've seen ambitious, and I'll tell you about mine in a second. But my question for you is there a way such that the attorney fee provisions of FEHA do apply when you're defending a client whose initial complaint was a FEHA-based complaint, they got counterclaimed?
Well, the FEHA statute itself, just as a whether it's brought by the plaintiff and he or she loses, or the defendant or plaintiff brings in some sort of a counterclaim. I don't know what machination it would be, but under the FEHA, the party against whom the claims are alleged, usually the employer, would have to show not only that they won, but that there was, like, in layman's terms, for the non-lawyers who may be listening or watching, that there was no good faith basis for the claim in the first place, right? It was a frivolous claim. There was evidence that during the litigation that would have convinced a reasonable person that there is no validity to this claim whatsoever. It could never be found in support of the plaintiff, and the attorney who brought the FEHA claim should not have continued litigating the case, essentially. Then and then only. That's a standard that's more recently was affirmed by the Court of Appeal, I believe. Can the defendant winning party, a prevailing party in a FEHA matter, go after their fees and costs? Now, I will also say, and this happens all the time in FEHA cases, because this statute, the FEHA statute, and the labor code, right? The labor code is very plaintiff attorneys fee friendly, not as much defense attorneys fee friendly. Just like the FEHA, it's very much oriented to incentivize plaintiff's attorneys to represent the small, individual who can't afford an attorney, right? To kind of counterbalance that, a lot of defendants will strategically issue 998s. They'll issue RFAs where that's triggers the burden to disprove if an RFA is not admitted to. So there are ways that shrewd defense attorneys can kind of push back against and use the same kind of attorney's fee sword, if you will, as a litigation tactic, even though the FEHA statute or the labor code is very much geared towards granting attorney's fees only generally to the winning employee if they win. There's still ways to push back against that, but even then, you still have to get your clients on the defense side's authority for a reasonable 998. It has to be done after enough litigation discovery has been shared. So it's not the same as the FEHA statute itself, the attorney's shifting provision in the FEHA statute or in the labor code.
But let me ask my question a different way. So let's say from the plaintiff's perspective, you file a FEHA claim and then you get a counterclaim. There's no argument made that fighting the counterclaim is in furtherance of the FEHA claim such that your defense work deserves its attorney fees as well?
So it will be very difficult to make that argument, because unless the counterclaim is somehow intertwined with this, like, legal theories and factual basis of the FEHA claim, such that the work that you're actually doing, the discovery the
Yeah.
questions that you're asking for your FIHA claim are somehow, in lack of a non-legalese term, is intertwined. It's one and the same almost, with the same discovery and work you would do to defend against the counterclaim. You're not going to get your fees if you're prevailing on the FIHA and on the counterclaim, unless the counterclaim, has some sort of fee shifting provisions in the laws themselves, of course.
Yeah, I figured it was unlikely, but
but what I will say is, and I think I have to look back, but this was one where my opposing party in this one case I have is being very ambitious. I think they may have this, is that a lot of times counterclaims are brought against plaintiffs based on some sort of breach of contract during their employment. And those contracts do have attorney's fees for the prevailing party. And so in that case, if a plaintiff is able to successfully, beat a counterclaim, they can then bring a fees motion on their work they had to do on defending against the counterclaim pursuant to that contract provision, which is separate from the work that they had to do to win on their FIHA claim and for those fees. So yeah, there are times where that comes up.
That's a good point. And so finally we figured out a potential mechanism based on contract. I had a case talking about ambitious defense motions. We had a labor law case. It was a class action. It was a federally adjudicated one because we had diversity jurisdiction. National defendant, very large corporation. At the time they filed their motion for summary judgment, which we defeated, they also filed a motion to get us decertified as class counsel. And the basis of it was that we had hacked their servers. And the way we had hacked their servers is because I just so happened to know one of the managers who worked for the company. He came to me as part of my investigation, and being a manager, he had access to a lot of emails. Well, I went ahead and downloaded all of those emails. It was about 52 gigabytes of information, but they were his emails. They were his documents. They argued because we looked at one of the former manager's documents that we had hacked into their server. Needless to say, it wasn't granted. I think part of the reason they even filed it was just to distract us from the MSJ, but neither of the motions were granted. Credit be given where credit was due. They were some of the best defense attorneys I've ever met. When I initially read the hacking motion, I was like, uh-oh. On a second read again, I was like, okay, no, this is very skillfully crafted. No one's hacked anything.
Yeah.
And every other lawyer who read it at first was like, wow, this is well written. But
Dan, what did you do?
No, but it was so obvious. Once the initial blast of this is a very well written motion and very subtle tweaks in the way case law was presented enabled them with a straight face to say that we hacked. But once you kind of took a closer look, it was obvious we didn't hack anything. And certainly we did not hack anything. But that was an experience. Let's talk about trends.
Yeah, sure.
What are you seeing right now? So look, we have 1102.5 has attorney fees. We have Viking River Cruises, if I'm not mistaking the case's name, with regards to PAGA actions and waivers of PAGA actions. And where is this all going in California, in your opinion?
Yeah, I think on one of your, one of the recent trends. So let's talk about arbitration. Okay, so arbitration is not new. This trend towards arbitration is not new. Class action waivers are not new. I do think, though, that PAGA is in a league of its own. PAGA, for those who are not attorneys, is the Private Attorneys General's Act. It's essentially a representative action, which is different than a class action, right? It allows a individual employee, private citizen, to step in the shoes of the state agency, which is the California Labor Commissioner, and to file a lawsuit against the employer in the shoes of the Labor Commissioner. And what the plaintiff in that case, pursuant to a PAGA cause of action, what that plaintiff is after is not dollars for that plaintiff or for the other employees who are called aggrieved employees as well. It's actually civil penalties. And 75% of anything that's collected in a PAGA lawsuit goes to the state. The remaining 25% goes to the individual aggrieved employees, usually based on how long they worked there. And yes, the attorneys who brought the case get their contingency fee as well. I think that PAGA has for a long time and will continue to be a sore spot for employers in California. I don't think that Viking River, I know that a lot of defense attorneys and employers were hoping that it would come out a little bit more aggressively and broader. But the Supreme Court's decision this year in 2022, the Viking River Cruises case, I think it'll be a little bit of a challenge for right now for some plaintiffs. But in the long run, I do not think it will have a substantial impact on PAGA practice. And the reason I don't think that is because essentially what the Supreme Court did, and I'm not going to get into legal weeds here because I think it can get very boring very quickly. But essentially, what made PAGA immune, if you will, from arbitration. Arbitrations have now for over a decade in California become very widespread, not just because you can get cases into arbitration and out of the public filing system of the civil courts, and not because you can avoid a runaway jury, but also because these arbitration agreements have waiver provisions, where when you sign it as an employee, you're waiving your right to have a jury in court, but also your right to bring an action on behalf of other employees. You have to bring your action individually. They're called class action waivers, representative action waivers. They're in their agreements. Read them, folks. Don't sign them, but read them. And then California, a few years ago, made clear that you cannot waive, you employer cannot force an employee per an arbitration agreement to waive PAGA claims. And the very simple way of explaining why is because in a PAGA claim, an employee is stepping into the shoes of a labor commissioner. And the labor commissioner is not a party to that arbitration agreement. They did not sign and say, we agree that the claims for on behalf of California, state of California should go to arbitration. So because of that, arbitration has still remained in civil court. And in fact, it's become, from my experience, one of the more primary claims as compared to class actions. When there's an arbitration agreement, for sure. That's what the claims proceed as a PAGA action. And the defense bar was very excited that Viking River would be the death knell for this process, because Viking River, the question, again, not legally specific, but in layman's term, the question was, can an employer force an employee PAGA action on behalf of all these other employees to go to private arbitration on an individual basis, meaning they cannot take this PAGA representative action into arbitration. They just have to go to arbitration on an individual basis, and the rest of the representative action cannot proceed at all. And what the Supreme Court basically said was, there's two types of PAGA actions. There's an individual PAGA claim, and there's a representative PAGA claim. And all the attorneys who've been practicing in this area were like, really? We didn't know that. Where did that come from? And you know what? The Supreme Court, it's called the Supreme Court for a reason. They just made it up. It's nowhere in the statute. Nothing in PAGA says there's such a thing as an individual PAGA action. And in fact, in my years of practice, I've seen judges in the past rule that you cannot bring a PAGA cause of action on behalf of one employee. There has to be a group. That is the nature of the PAGA statute. It's to be brought by the state of California on behalf of a group of aggrieved employees. So as to avoid, one employee filing a PAGA cause of action to get civil penalties only on behalf of him or herself. But the Supreme Court said, nope, there is such a thing. There's an individual PAGA action. And if an employee signs an arbitration agreement with a representative waiver, that individual PAGA action goes to arbitration. And then what do you know? The Supreme Court also said that because the individual action goes to arbitration, that individual no longer has standing in the court case to proceed on the representative PAGA action. So that representative PAGA action has to get dismissed. Now, at first reading, that might seem like that's a death knell for PAGA. But from a plaintiff's counsel perspective, thankfully, it's not. And the reason it's not, in my opinion, is because that was the Supreme Court interpreting a state law. And that is not binding. The Supreme Court, just like in the dissent, Sotomayor said that, the Supreme Court's interpreting California law this way, but that's for a California court to decide. And they may find that, an individual claim can be sent to arbitration, individual PAGA claim to arbitration, but the representative claim could still remain in court.
Yeah.
The plaintiff doesn't necessarily lose what's called standing to proceed on the PAGA case in civil court on the representative basis for other employees, even though the individual one gets sent to arbitration. That's for a California court to decide. And there is now, before the California Supreme Court, the Adolf versus Uber case that's going to be decided. And I hope will be decided correctly, such that it will be found that even if there is this fiction of an individual PAGA claim that gets sent to arbitration, the representative PAGA claim should still survive and proceed in civil court.
Yeah.
And if that is how it turns out, then I don't think Viking River is going to be any sort of a death knell or close to it for PAGA. PAGA will survive. Those cases will continue. Class actions, in terms of trends, I expect, and I've seen this happening more and more with plaintiffs' attorneys, that as more and more cases get sent to arbitration, if those class action waivers are not written correctly, what you find sometimes is mass arbitrations. Where you file, you want to send these cases to arbitration and you can't file as class action. All right, we're going to file 50 arbitrations because there's 50 putative class members, right? And, for my defense side, years, again, it's a little dated, right? Pre-2015, arbitration provisions and agreements and the strategies then, I think from my conversation with defense attorneys today, is a little bit different. In those days, early 2010s, it was get arbitration agreements out, get them signed, and update them as you need. But arbitration, it's going to solve all your problems. Not so much in those terms, but there was less hesitation to proceed and send out arbitration agreements, particularly larger employers where they faced significant risk of class actions. Now, I think defendants, a lot of times employers, are having second thoughts because arbitration can be very expensive.
Yeah.
Whether it's a mass arbitration or a single plaintiff arbitration, arbitrations can get very, very expensive because the employer has to pay for all of it virtually. In some cases, they even have to pay for the deposition costs. So it is not, I guess, in terms of a trend, arbitration, I think, is still very much a top priority for employers. Get them enforced and get it out of a jury's hand. But I don't think it's the end all be all it once was considered to be by the defense bar, by clients on the defense side. And I also think California, the legislature and the governor, is still going to continue seeing what they can do to allow avenues for employees to have a right, despite the Federal Arbitration Act, to have a right to not be forced as a condition of employment to sign an arbitration agreement. And I think that's what's one of the issues that's before the courts now.
How much time do you have? It's already 5. I don't know if you knew that.
I got another 15 at least.
Okay, good.
Yeah.
So it's an interesting thing. I love going to these defense seminars. And before COVID, I don't remember how many years ago, I went to one for Gibson Dunn. I don't know what it was. And the attorney who was handling it, I'm not going to mention the gentleman's name, but you know who he is, kind of a big figure in the defense side, employment practice. And he writes a bunch of books and this and that. He's talking about PAGA. And he said it was a Governor Gray Davis who put it in. And his point was that came to fruition after Davis got recalled, or it came into fruition because Davis got recalled. He was getting recalled. So he came up with a law that this defense attorney calls the sue your boss law. That was then, things may have changed since then. I actually interviewed Kelly Knight, a mediator. I'm sure you know who he is. Actually, this week, Monday of this week. And he also brought up the Adolph case. And I asked him, look, how is this affecting your mediations? And he said some plaintiff attorneys literally just put their cases on hold pending the results of Adolph. But he's like, look, as a mediator, it's my job to get these resolved. And I point out to some of these plaintiff attorneys, the Adolph case might not hold in your favor. It may not. I mean, I think it's California. I think we know how it's going to go. I think, the creation of PAGA in and of itself, which to some extent, as you pointed out, maybe substantially, if not almost entirely, supplants class action. The creation of a law that enables that in and of itself gives you at least a flavor of where the legislature is at. And it's a liberal state, so it's going to be pro-employee. So I more side with your perspective, which is we really should wait and see what happens.
Yeah. I mean, I would also, I know Kelly, I haven't mediated with him yet, but I know, and I've had mediators tell me that, and I tell them, what's funny? The California Supreme Court who's deciding Adolph, that's the same court who found in the Kim v. Raines case, I think it was, that this exact issue has already been decided. That if you settle an individual PAGA claim, an individual plaintiff has settled all their claims, they can still proceed on a representative POG Act case. So be my guest. Let's wait. Actually, what I found is not so much plaintiff's attorneys pausing cases as much as defense attorneys trying to use Viking River as the end all be all and get one past the judge, and trying to not just take the individual POG claim to arbitration, but actually ask for a dismissal of the representative POG claim, even though, because that's what the Supreme Court said, but even though that's not controlling, and despite the Adolph cases pending. And so what I've seen in the plaintiff's bar, and I have some myself, is we are having to fight these motions to dismiss the representative POG claim based on Viking River, and just making sure the judges see that this is not a decision that's actually been made yet. Supreme Court is pending on this. You should hold off. And so pausing it, and that's assuming the arbitration agreement is written the same way it was written in Viking Rivers. Okay, yes. All defendants seem to be, they see Viking River and they want to file their motion to dismiss and compel arbitration, a motion to dismiss. And I'm like, hold your horses. This arbitration agreement in Viking River is not the same as your client. I've had a couple of those conversations too, and they still file it. I don't know, maybe they're thinking the judge won't read get into the weeds of Viking River or the arbitration agreement here. Fine, file it. I had that same conversation. Welcome. If you file that and I win, your client's going to pay more. Just remember, you're racking up the fees, not me, right? So I think right now we're in a wait position. We're just waiting to see how the Supreme Court comes down. I'm a little more optimistic, but I don't think that this is the end either. I think the defense bar, an employer in California, whether it's through ballot propositions, my opinion, misinformation, will try to somehow undercut POGA's effectiveness. And I think, and I know it's not obviously a position defendants agree with, but I think POGA as a statute, when done by attorneys who take it seriously and are not just mass filing without doing their diligence, is one of the most effective statutes in terms of enforcing labor laws in California. Because otherwise, so many I can't tell you how many folks call me and they have clear wage and hour violations. Yeah. And I can't take the case because they signed an arbitration agreement. And there isn't enough, the POGA side of it, in one reason or another, we don't take it. And we just send them to the labor commissioner. And they have to go through and hope that the labor commissioner in a year or a year and a half will have a hearing, because they're backlogged and they're not properly staffed. That's why there is the POGA. So, in terms of getting, and the last point I'll make about this, Dan, is because the listeners may be listening to this, and I'm kind of actually pretty passionate about this, because I think I know what's coming in terms of characterizing POGA as this like punishment of employers and just attorneys trying to get money. And here's what I'll say about that. We attorneys on the plaintiff side actually don't have that intent. The California legislature passed this law as not a recovery mechanism for employees. It is a law passed in order to penalize employers to change their conduct. It is not a law that was intended to be used so as to recover money for employees. So when you may see ads or hear employers or defense attorneys complain that these are just lawsuits to harm employers, and this is why all the employers are leaving California, well, first of all, other states are going to start doing this. California just begins the process usually, if they haven't already. And second of all, no, employees are bringing these claims because the employers are violating the law. Otherwise, they wouldn't be settling them. And they're paying that money because otherwise they wouldn't change their policies, right? So it is supposed to be a punitive, not punitive, but certainly a punishment, if you will. I don't want to use the legal terminology for folks who may not be lawyers. It is not supposed to be a recovery of funds. A class action is intended for recovery of funds. An individual lawsuit is intended for recovery of funds. A POGA action is a labor commissioner punishing an employer for violating the law. Nothing more, nothing less.
Yeah, civil penalties. That's the idea. I understand. On a lighter note, do you remember when you and I mediated a case from 9 or 10 a.m. to 2 or 3 in the morning?
Still holds the record in my book.
What the hell?
Yeah, I mean,
what the hell was that?
For those who are listening, it actually did settle at around 11 o'clock at night. I think 10 or 11. We got to the number, and then around 10 or 11, mind you, And remember, in that case, we had like 5 clients.
7, I think.
7.
Yeah.
And that was when we would actually show up in an office in person for a mediation. None of this Zoom stuff, right? So you had spent a full day from 9 o'clock or so in the morning until 10 or 11 o'clock at night. Lunch, dinner, breaks, everything. All day. And at 10 or 11 o'clock at night, as we're drafting the settlement agreement, remember what the issue was?
I don't know.
For another 2 or 3 hours, and I think it was about, I was driving home at 3 a.m. It was that there was a concern that the employer had that some of our clients were going to like steal their trade secrets.
Yeah.
And it was like a restaurant business, and they were worried that some of our clients who were worked as waiters or chefs or something were going to steal some of these recipes and go open up a competitive business. And so here we were at 11 o'clock at night after 12 hours of mediating, coming up with like clear definitions of recipes that cannot be, of products that cannot, or the recipes of which cannot be taken. And it was, I mean, to this day, I use that case. It's funny you bring it up. Because when I prep my clients for mediation, I say, listen, mediations, I've been in them until 3 a.m. This one won't go until 3 a.m. but it's funny because, and I know we got to wrap up, but in terms of trends, I actually think in practice, right? Not law, but practice, some of the biggest trends are how, look at us. We're here. We're remote. And I think this is not going away. Depositions may go back for strategic reasons to in-person. But I don't see mediations, and I don't see every single court hearing going back to being in person. Nor do I see clients, particularly paying hourly, wanting their attorneys to be paid for travel time and sitting around time and so forth, right? So I don't know. I wish in some ways I knew how the defense bar and their clients are managing that. And I think I would encourage you, if you haven't already, if you have a defense attorney who's currently practicing on that side, asking questions about how their practice has changed. Because I'd be really curious to see how with some of the efficiencies that COVID has brought, because forced us to be more remote and so forth, how their practice has changed in terms of their billables and what their clients' expectations are, and what is and what is not billable and so forth. That's been very interesting to me as a changing trend as well.
Yeah, that would be interesting. See how they bill for Zoom and all that type of stuff. Well,
yeah,
Sam, it's this went by real fast, and you've been very generous with your time. We've been here over an hour, I think. I think anyone who's practicing employment would benefit from this podcast. I think the information that you have, I was not to toot my own horn, I was dead right. Speak to people who have experience on the other side because they provide you enlightening perspective. So thank you dearly, sir, for coming on today and spending your time. I've missed you. It's nice to speak with you. Any final words before we wrap up?
No, thank you very much for having me. I, really appreciate the opportunity. I love employment law, so the chance to talk about it, I always welcome it. Happy to come back anytime, Dan, if there's a subject you want to chat about, or just give me a call. But no, thanks for the chance to be here, man. It was a great time. Thanks a lot.
I appreciate it. We'll bring you back and continue this series. Thank you so much.